This is the Darshan Talks podcast, regulatory guy, irregular podcast with host Darshan Kulkarni. You can find the show on Twitter at Darshan Talks or the show's website at darshantalks.com.
Hey everyone, welcome to another episode of Darshan Talks. I'm your host Darshan Kulkarni. As you know, it's my mission to help patients trust the products they depend on. And these products sometimes are food products. So I'm an attorney, I'm a pharmacist, and I advise companies with FDA-regulated products. So if you have an interest in FDA-regulated companies or their products, this is the podcast for you. So today's podcast is about food. It's about the claims that food companies make. It's about the types of claims that may inspire you to pick up a product and go, you know what? This is what I've been looking for. And we've all seen that happen in the context of meats. We've seen that on the labeling on your favorite ice cream. And we've seen that with the most delicious cheeses that we use. So our talk today is actually going to end up being about cheeses and cheese labeling and cheese advertising. So if you are a food manufacturer and you're in the business of looking at labeling, you should care about today's talk, because this is going to talk about some of the concepts that you should be thinking about when you review your label. Today's guest, she is someone we've had over more than a few times. She's an experienced intellectual property lawyer with an extensive background of over 30 years of practice in trademark, patent, trade secret, and copyright law. I have to say, she doesn't look like she's been working in this for 30 years. I think she's barely 30. She provides broad-based and strategic intellectual property counsel to companies of all sizes relating to litigation, prosecution, and transaction variety of industries, including clothing, accessories, textiles, jewelry, furniture, fragrances. And she's currently partner at, and food and beverages as well. She's currently partner at Royer Cooper Cohen Braunfield. So say that 3 times fast. And welcome again, Donna Tobin. Hey, Donna.
Hi, thank you. Can you hear me okay? I hear static. You good?
I can hear you fine, but I do hear some rustling.
Okay.
So Donna, let's talk a little bit.
So I just want to point out, the reason you said that is because you haven't seen me in person in a while, only on Zoom. So
I was
anyway,
talking.
Go ahead.
Before we started, I was talking a little bit about how you look like the quintessential New York lawyer in some of the pictures you've sent to me from the PowerPoints that you've done. So I do believe that whether or not I see you, you might be younger than 30. So what do I know?
Barely able to practice law, if that was the case.
Barely able.
Okay,
That's right. That's right. So Don, let's talk a little bit about the labeling and advertising of cheeses. And you think that that's not something that is that perfunctory? Is that an issue that you've gotten pulled into? Why is this an area that you found companies reaching out to you about? What are the typical 4 or 5 issues that get brought up to you?
Yeah, many reasons. And, if you look at buckets of reasons.
Buckets of reasons, yes.
Right, so there's the...
It's like binders of women and buckets of reasons.
All this nifty stuff that...
Sorry, please.
Exactly. Can we protect all this nifty stuff we're doing on our label? Yeah. We're spending time, graphic artists, we're thinking about things. We have unique presentation of our products and our label. Can we protect it? That's one thing. Will we get into trouble by using some things that maybe somebody else is also doing? That's another thing. Those 2 things are really what I look at. Mm-hmm. The third thing is more something that, people who are looking at regulatory issues and that sort of thing will consider, which is the government going to have a problem with what we're doing? Is it going to be more than just some competitor coming after us, right? Do we have some type of regulatory issue? Yeah. And interesting thing is when we are looking at what the Trademark Office will protect and register, they don't really care whether what you put on your label violates some federal rule other than the trademark rules. And right. So they need people like us who are looking out for all those buckets, because they're different. There are different ways of looking at the same thing.
Yeah. So we've talked about the big buckets. Your big buckets, as you pointed out, are can I do this? And is someone else going to prevent me from doing this? And the can I do this can be split up into me personally. Will my competitor stop me? Will my will the government stop me? And quite honestly, will someone inside the company stop me? Those would be the three major angles I would think of. So let's talk about a few of these issues as they pop up. And are there issues that are unique to cheeses that you've sort of found yourself dealing with? And what I mean by unique to cheeses is, I'll give you an example. You and I have worked through a couple of these products before, and one of the ones that we keep hitting is the quote unquote all natural. When people come to you with that label, what sort of sets off your buzzing, if you will? Why are people going, okay, do you think there are concerns around the use of all natural?
Not from an intellectual property protection or enforcement standpoint, honestly. But I would call you, to tell you the truth. Obviously there are regulations, I think, around what you can say in terms of all natural and not, and what has to be in your product. But if the Trademark Office looking at a label that had all natural on it, frankly, what they might make you do is disclaim any rights in the words all natural so that you can't stop anyone else from using it. That's it. I mean, there's no real analysis into what your product is. They're looking at it only in terms of what are the words on your label and how do we parse this out. So all natural is not a brand, it's not a trademark. Just don't want to make sure you don't own all natural. That's really their analysis. So when I look at that, I don't really focus on whether it can be there or not. I focus on, is it protectable, and then turn to you to see if it can actually even be on the label.
And that's really where we start sort of having this back and forth. And I think that's where the beauty of some of the work we do is. And what I'm thinking about is we often get clients who come to us and go, oh, Darshan, you pointed out to me that there, and just to answer the question, there are definitely FDA, USDA type of issues that I'd start considering around all natural. We've got to look at the definitions and see if it rings off any bells. And there are definitely bells that are ringing for me with all natural. However, what if a client came to you and said, you know what, I'd like to protect naturally made instead of all natural. And they come to me, I'd go, well, I want to look up whether that term naturally made has any legal implications. And maybe it does, maybe it doesn't, but let's assume for a second it doesn't. Does that ring off bells for you, or do you want to suddenly start saying, I want to protect that? Or does everything that is potentially protectable not need to be protected?
Well, there's a couple different questions in there, right? So the first thing is everything that is protectable should be protected, but it doesn't have to be registered with the US Trademark Office or Copyright Office to be protected. I mean, in the US, if you use something on a product in interstate commerce, you start to develop common law rights in that property. So, for example, if you sell cheese with naturally made, setting aside the trademark problems you're going to have with it, which I'll bring up in a second, if you start selling something with that name on it, arguably you are developing common law rights. If you sell it from New York and New Jersey, you have rights in those two states, but you don't have federal rights.
What are common law rights?
Unregistered.
Okay.
Essentially, they're unregistered, so they're not federally granted. They're unregistered rights, like an unregistered trademark. So if you use a trademark in interstate commerce in 3 states, in New York, New Jersey, and Connecticut, let's say, but you don't register it with the Trademark Office, and then you start using my trademark in New Jersey, I can sue you. But if you start using it in California, I can't, because I don't have a federal registration and I never used it there. So common law rights are limited to what you actually do. Federal registration gives you nationwide rights, expands what you actually do to the whole country. So if you sell it for cheese in New Jersey, those are your rights. Those are limited common law rights.
So here's a real question. In that specific situation, when you're talking about common law rights, do you have to, like we spoke about this last time you were on, we talked about CBD, and we talked about this idea of state registration. Do we, in this specific instance, if there were common law rights, does it still make sense for people to go and register in the state, or do you not need to bother at that point?
That's a good question, actually. So if you have common law rights in New Jersey, I mean, I'm not aware of every state's statute in terms of whether you get different types of damages if you register versus not. You know, you might be able to get attorney's fees. I'm just not sure of every state.
Yeah.
But you can enforce unregistered rights, so even in a state, but you may be entitled to more things if you bothered to register.
Got it. So the advantage would
even on a state level, but
yeah.
I mean, that's typically different requirements. If you register, you can get different things, but if you just have a common law right in a state, you can enforce it just like you can, you know, in multiple states. Registration expands your rights.
Got it. So now going back to naturally made, in that scenario, let's say you have a cheese client who comes to you and says, you know what, Darshan says that there's no, and again, we don't know without looking, but, and we should probably put that disclaimer, that not legal advice. But let's assume that Darshan says,
maybe not even right.
But let's
check that out.
Yeah, exactly. Darshan says there's no FDA, USDA type of issue there. Would you tell them to go register naturally made, or do you think that someone's likely to push back on it? And is it worth it? It doesn't matter.
So a couple of basic tenets in trademark law.
Please.
One is you can't remove descriptive or generic terms from the lexicon, meaning you can't stop people from using words that do not have branding significance. So when I see naturally made, it means something to me. It doesn't mean it comes from Acme Dairy. So the purpose of a brand is you know where it comes from, right? You see something with craft on it, you know where it comes from. You know their reputation, their products, their quality, whether you think it's great or not great, you know what it is, right? If you see naturally made, it doesn't mean it came from anywhere. 50 different people could put on naturally made because it refers to a quality of the product. So on the one hand, it's not a branding function. No one knows that that's a brand. It doesn't function as a brand. On the other side, you can't stop other people from using things to describe their products. So I would, out of the gate, not even consider that as protectable or registrable. I mean, you know, if you did it to something that clearly was not naturally made, like a moon rock, I don't know, is that naturally made? Maybe you could make some argument that as applied to a moon rock, it has no sense and it's actually a brand. I don't know. Like if you take Apple as compared, you know, on a computer, Apple doesn't mean much of anything, but still it's different. Naturally made is a descriptor. If you could find something that can't be described as naturally made, you could make an argument, but I don't think it's worth your time.
What I'm hearing you say is using something naturally made would be the equivalent of using this image locally produced. It doesn't mean anything, so it may not be protectable. Or more appropriately, it means
something, but it's not a brand.
Right.
It describes the product. It does not indicate the source of the product as a company or a brand. It describes the actual product, and you can't register something actual product, except there are certain did I lose you there?
For a second I did.
Okay.
You kind of broke up a little bit there. But
so take American Airlines. That tells you that's an airline in America, right? Like how do you stop anybody else from using that? But it's become so well known over time that a descriptive term could become a brand. I think it would be very hard for something like locally made But if you were the only person using it for 30 years and you put millions of dollars of advertising in, maybe. I mean, that's how those descriptive terms become a brand, is overuse. But locally made, locally produced really describes something about the product and is descriptive, or even, a generic reference to how it's produced.
So now, instead of locally produced, let's say it said made in Wisconsin.
You're looking at my my fanciful cheese here, right?
I am looking at your fanciful cheese as we speak. But
Okay.
it's, instead of saying locally produced, let's say it said made in Wisconsin. Can I, as a cheese company in Wisconsin, own that, or was that necessarily owned by the cheese producers of Wisconsin, and that's a registered trademark for them? Does that question make sense?
Yeah. So if you said made in Wisconsin, you could put that on there. Again, you couldn't register it as a trademark.
Got it.
You could put it on there if it's true, right?
Right.
If it's not true, the Trademark Office may ask you, but they may frankly not, but regulatory people would, right?
Yeah,
but you know
exactly.
that there is a logo with, with cheese Wisconsin, made in Wisconsin seal. That's called a certification mark, and that is
Okay.
registrable as an organization certification mark. So they let you use it, and it can be registered in the Trademark Office, and they let people who they certify use that. So it's called a certification mark. You have to have certification guidelines that are actually written in the Trademark Office. Believe it or not, asks to see them. So what do you use to certify? It has to be made in Wisconsin. It has to be from cows that are in Wisconsin. I'm kind of making this stuff up, but the milk can't come from some other state, that sort of thing. And then that certification mark, that logo with the cheese that we've probably all seen, that can be registered in the Trademark Office by a certifying entity.
So let's talk about certifying entities, because it's something that has been raised to me more than a few times. What does it take to become a certifying entity? Do I need to do anything specific, or can I just say, I'm making this up? And I'm going outside the scope of cheese, but let's say I wanted to create best lawyers and create a certifying mark around best lawyers. Is there anything that stops me from doing that and just going and registering a mark and saying best lawyers means people who Darshan thinks are the best lawyers? Or is there more to that? Do I need to have a test? Do I have to do anything?
Again, from a trademark standpoint, you have to do something. You can't just come up with that and then not enforce actual certifying concepts. It doesn't have to be approved by, the things we're talking about don't have to be approved by any government agency. If you said, I don't know, there are probably certifying things that have connections to the government that you do have to, have approval for. But, if you wanted to start something yourself, or let's say, prosciutto di Parma, right? So that's a certification mark. They register that as a certification, or Parmigiano Reggiano. Let's stick with that because it's cheese, right? That's a certification mark, and people who sell Parmigiano Reggiano can use that, and it's registered in the US Trademark Office. In Italy, it's something else. It's called a Geographical Indication and a symbol of origin. But in the US, it's registered as a certification mark, and they had to prove it has to be made in this, certain square footage in Parma. Cows have to come from here. It has aged for a certain amount of time. It has to have certain weight and all sorts of things. And if you comply with that, you can put that Parmigiano Reggiano on your cheese. And that the rind, they have like dots on the rind that say Parmigiano Reggiano. That is registered in the US Trademark Office. And so the certifying entity there has to approve whether you can use that on your cheese or not.
So what is the difference between a geographical mark and a certification mark?
Country. Quick answer is country. Geographical indications are a hot topic in things like cheese. In wine, it's a little different because I think they had a better lobby than the cheese lobby. So, you definitely, champagne is a no-no unless it's actually made there. But things like, are you still there?
I'm still here.
Okay. So let's take prosciutto di Parma. I'm sorry, keep like meat on my mind, even though I'm a vegetarian. Let's take Parmigiano Reggiano. In Italy, it's called a geographical indication, or GI, which means you can't use this indication unless it really comes from there, right? But in the United States, we don't enforce those things. The Italian government actually enforces them. This is a government subsidy type of thing to bring money into the country. Everyone comes to Italy to, have these products that come from different regions, right? But in the US, we don't have, greats who made cheese from the 10th century. And so here it's a different thing. We don't enforce them. So if someone from a country that recognizes geographical indications wants to enforce it in the US, they have to use our system. And our system is either trademark, certification marks, membership, other collective membership marks, and they have to shoehorn themselves into our system. So unless you can get a registration for feta cheese or, Edam cheese over here under our trademark law, then you can't enforce it here. So the Gorgonzola people were able to register their mark Gorgonzola, not as a certification mark, but just as a mark of cheese. And so here we'll enforce it because it's a US trademark. There's a lot to think about. It has to fit under one of our trademark paradigms or it won't be enforceable here. So, and the Italian government can't come over here and stop you from using, Parmigiano Reggiano.
So what I'm hearing you say is that what you really land up with is a scenario where companies, if I am, for example, a Parmigiano Reggiano maker in Italy, and I'm trying to commoditize that or commercialize that in the US, I can go down the certification route and have a set of criteria and say these are criteria you need to meet for you to be able to claim that this also is Parmigiano Reggiano. And I assume as part of that, you have to become part of a consortium and therefore pay some money to that group, and that's how they make it. Or you create another trademark and basically sub-license it, I imagine, so that can be used. Why would a company...
Or use it yourself, right?
I'm sorry?
The difference between registration, regular trademark registrations and certification marks is the certification entity, and when we're talking about US marks here, that certifying entity doesn't make anything. They don't make cheese. They only certify other people. But if you have your own name that you want to register, you can get it through, then you can sell that cheese under that name.
But can it also enable other people to sell it as well as a sub-licensed mark? Oh.
Yes, as a sub-license. You can't have something that's a certification mark and a regular trademark, but you can sub-license.
Right.
Yes.
Okay.
Yes. Yes.
Okay. So if I'm a company that is still trying to figure out what the best way for me to commoditize this or commercialize this is, why would I give up the right to figure that out by having very strict conditions right now under which it becomes a certification mark? Isn't it simpler to just go, I'll decide whether you meet the criteria. Now that those criteria keep changing, therefore I'm just going to sub-license it to you, not worry about creating certification criteria. Does that question make sense?
Not.
Do that again?
Yeah.
let me try that again.
Keep in mind also that there are some things you can't get regular trademarks for. Like you can't get a regular trademark, for, maybe you can, but the Roquefort people didn't go that way either. what they want, or the Parmigiano Reggiano people, is this is something that comes from from the region in Parma,
Right.
and so we're registering the stamp of approval almost, right?
Right.
So it's different than a brand that you come up with, and a lot of these geographical indications don't really fit well into brand, like
Right.
so much as a type of thing that's monitored by a certifying entity. Does that make sense?
It does. But now I'm sort of going back to that Wisconsin cheese that we were discussing a few minutes ago, or made in Wisconsin. And in those specific situations, would I be able to create a different mark, so a different logo, if you will, but it still says made in Wisconsin? Or does the likelihood of confusion standard apply at that point still, even if it looks completely different?
If it looks completely different, then it wouldn't be likely to be confusing, right? But the quick answer is it would apply.
Okay.
And who would be making that determination? A court or the trademark office? I mean, if I'm not sure this answers your question, but if you look at my fanciful pink star, which hopefully we get to talk about product configuration trademarks too, and colors, although we're running out of time.
We're definitely doing that in another podcast.
Okay,
we're already at 30 minutes.
Look at that logo, okay? So that logo has a lot of things: organic, all natural, farm fresh. You might be able to get that logo registered, and then someone else used those names in a different looking logo, they might be able to get that registered too, as a trademark, right? But whether those things are true, whether it's all natural, is a different regulatory analysis.
Correct.
That logo alone could be registered as a trademark, arguably, unless there's something similar.
So speaking from a regulatory standpoint, I would strongly advise against it, because you might get that logo registered and approved, but you can't use it because the FDA or USDA may come out and say, you don't meet those criteria, therefore you need to stop using the logo, because it's confusion.
It's the same as what happened with green. Everyone rushed to register green marks.
There you
but
go.
If something that you were using wasn't actually comporting with what everyone thinks green means, you had regulatory problems. Honestly, the FTC would.
I mean, you and I find ourselves dealing with FDA, FTC, USDA issues all the time. Speaking of, by the way, Donna, how do they reach you?
Email is best. DTOBIN, Donna Tobin, DTOBIN @rccblaw.com.
Very cool.
So the question for next time is, can you register the color pink for cheese?
What's a question you want to ask the audience, by the way?
Would they eat a cheese that's pink?
That's a great question for the audience. Would you eat a cheese that is pink? That is the question. So during this podcast, Donna, we'll end up discussing a variety of issues. Everything from how protectable is all natural to is a pink starfish protectable as a cheese, the meaning of registration marks versus trademarks versus geographical indications, and what does locally produced mean, and the implication of having a logo that may have terms that you cannot use. So there's a lot of issue spotting that happened. Did I miss anything?
I don't think so.
Okay.
You got it. You must have been taking notes.
I didn't actually this time. Nothing in this podcast, as we discussed, should be construed as legal or clinical advice of any kind. It is intended for educational and entertainment purposes only. Again, Donna, where can they reach you?
DTobin @rccblaw.com.
And if you like this podcast, please leave a comment, please subscribe. You can find me at Darshan Talks on Twitter, or go to our website at darshantalks.com. Thanks again for coming on, Donna.
Thanks for having me.
This is the Darshan Talks podcast. Regulatory guy, irregular podcast with host Darshan Kulkarni. You can find the show on Twitter at Darshan Talks, or the show's website at darshantalks.com.